Hello, thank you for joining me in a discussion of collaborative divorce. My name is Olga Stambler. I'm an attorney in Chicago. I practice at the firm of Hurst, Robin & Kay, and I concentrate my work in all areas of family law. I do traditional family law, but in addition, I also work in collaborative divorce, and I'm a trained mediator as well. Today, we'll be talking about collaborative divorce, and I thank you for showing an interest in the topic. I'd like to first go over some of the things, the areas of collaborative that we're going to explore and talk about in more depth. First, I'd like to start out with an introduction just to explain what the process is. Then talk very briefly about the history of collaborative divorce, just to give it some context and framework. I would then like to talk about the collaborative attorney. The collaborative attorney is, the mindset and process is different of a collaborative attorney compared to a traditional litigator, so we're going to explore that a little bit further. Then I'd like to talk about the role of the collaborative attorney and what the role is in terms of facilitating a collaborative divorce. Then we're going to talk about some of the documents that are involved. The retainer agreement, which is different than a retainer agreement in a traditional divorce litigation case. There's another agreement that needs to be signed, which is called the participation agreement, that all parties, professional and the actual parties, would need to sign, and so we'll go over that. Then we're going to discuss what goes into really evaluating whether a candidate that comes to a potential client is a good candidate and a good fit for the collaborative divorce process. Then we're going to go over an entire case from beginning to end and talk about how that flows. I'd like to, after that, talk about the team members that are involved in a collaborative divorce case. And finally, talk about some actual cases and case history. Well, I'd like to start out with basically introducing what is the collaborative process. Collaborative divorce is an alternative to traditional litigation where the parties commit not to go to court. It involves a team approach. It includes a team of collaboratively trained professionals. Not just attorneys are involved. It would include a mental health professional that would serve as a divorce coach to help the parties really facilitate their communication. It would also include a financial neutral that helps the parties untangle the financial aspects of their families, look at cash flow, look at assets, and really help them look at different options to work towards a positive resolution. The parties make a commitment to the process. They make a commitment to honesty, to integrity, to an open mind, and to full and fair disclosure. And they make a commitment to prioritizing the needs of their children. The attorneys also make a commitment. They make a commitment to use an interest-based, problem-solving method of negotiation to facilitate the process. The parties participate in face-to-face negotiations in a series of meetings throughout the collaborative process, which is always supported by all the collaborative professionals on the team. So what is the result and what is the benefit? Why do we do this? Why is this good? The result is that there's an entire team that supports the family. There's an entire team. It is a holistic process. So really all aspects of what is needed to address the deconstruction of a family and reconstruction of two family units is addressed, supported, and worked out in a way that the parties are completely involved, committed, and are the architects of their own settlement. Why is this a good thing? It's a good thing because all of the negatives that one can think about in a divorce, it's time-consuming, it's stressful, it deteriorates relationships, it breaks down communication and trust in terms of any kind of co-parenting, it's expensive. All of these negatives are worked in a much better way for the family. The parties focus on communication, so their relationship is actually benefited. The stress is reduced as compared to litigation. The animosity is addressed through coaching. The process is thoroughly supported and controlled by the collaborative professionals, and so the parties are the ultimate architects of their settlement. This is good because in traditional divorce litigation, there's a high degree of post-decree litigation because parties can't adhere to settlements that are imposed upon them by courts. When parties are committed to their settlements, when they are the architects of their settlements, there's a much higher degree that that settlement will be adhered to. And therefore, in a collaborative divorce situation, post-decree issues are much less common and much less frequent. So in summary, unlike litigation where stress can really destroy a relationship, the collaborative process is not only less expensive and less stressful, it really works to enhance and rebuild and redefine the relationships in a family so that they can function on an emotionally healthy level moving forward. Now let's talk about the history. Where did collaborative movement come from? Where did the collaborative process come from? And this I'm just going to touch on very briefly. It started in the 1970s with an attorney in California named Forrest Mostyn, who came up with a way of handling divorce that's less expensive and more available to the general public. And he called it unbundled limited scope services, where he would offer discrete limited services, not litigation, in a legal clinic model. From there, the other interest in the California area started to develop. A very famous family law practitioner named Pauline Tesler in the 1980s started studying cross-cultural anthropology and looking at adversarial cultures and their process for conflict resolution. Around that same time frame in the 80s, an attorney in Minnesota named Stu Webb also made a revolutionary change in his family law practice and announced that he wouldn't go to court at all and that he would only handle family law cases in a settlement situation. In that same time frame, in the early 90s, a psychologist named Peggy Thompson and a social worker named Nancy Ross, both in San Francisco, started to offer an interdisciplinary practice, and they called it collaborative divorce, where they integrated attorneys and mental health professionals to develop a comprehensive support team to facilitate an amicable, non-adversarial, and non-litigious divorce. In the late 1990s, these professionals, Tesler, Webb, Thompson, and Ross, all connected, and they started offering training to other professionals in an area called collaborative law to lawyers around the country. In 1999, collaborative lawyers, mental health professionals, and financial professionals formed the organization which would later become the International Academy of Collaborative Professionals. It convened its first international conference in Emeryville, California in 1999 with 50 participants. In 2001, 5 attorneys from Illinois traveled to Wisconsin to be formally trained in collaborative law, and they formed the Collaborative Law Institute of Illinois, which exists today and has almost 200 members, and I'm proud to be a fellow. Today, the IACP, the International Academy of Collaborative Professionals, has grown to 5,000 members in 24 countries, and collaborative divorce is a recognized alternative dispute resolution for handling divorce all around the world, and it's growing rapidly. So now I'd like to talk about a very key and important part of collaborative practice, and that is the collaborative attorney. When an attorney or any professional really starts to explore collaborative divorce, there is a shift in thinking, and the term of art in the collaborative divorce field is called a paradigm shift. And really what this requires, particularly of a litigator, is a fundamental shift in approach, in thinking, and in process. And a lot of the training for an attorney to become a collaborative professional really is a rewiring of the process, the thought process, the negotiation process, and the handling of the case. It starts with an exploration of alternative dispute resolution models, including mediation, to really refine and retune how a negotiation is handled. It requires a fundamental change in approach and assumptions, and it basically replaces a former way of thinking and problem solving with quite a different method. So what does that look like? What is that shift in thinking? Well, first, there's a shift, one of the most important shifts is the shift from positional negotiation to a needs and interest-based negotiation model. So what does that look like? That could look like a client coming in and saying, I have to have the marital home. I have to live there. And then the attorney advocates for that position, and that's the positional stance. Looking at needs and interests is really delving in with the client about, well, why is that the case? Is it the need for security? Is it the need for consistency for the children? Is it the need to have a constant home environment? What is the underlying basis, and how can that be achieved in a variety of different ways to explore different options to address those interests and see where the interests might be aligned with the other side? Does the other party also have a need for the children to feel safe and secure? Where can there be an overlap in discussion? That's an example of a shift in the thinking and a shift in how a client would be handled, or a client would be guided, rather, through a needs and interest-based discussion and a needs and interest-based model of negotiation. In a traditional litigation case, the attorney is really focusing on legal concepts. In a collaborative divorce case, of course, the attorney educates the client about the legal issues involved, but the focus is on the client's values. The focus is on facilitating a creative problem solving that includes not just the attorney, but really draws on the entire interdisciplinary team, promoting the client's self-determination. So again, that would look like really a much more in-depth exploration of the client's background, issues, and concerns to really help the client themselves unearth and vocalize their needs and interests, and let that versus the law really guide the settlement, the discussion, and the process. The next important consideration in terms of how a collaborative attorney handles a case versus a traditional litigator is the process and control. Litigators are used to being in control of the case and in control of the process. The focus is different in collaborative divorce. Lawyers really work in partnership with their clients and with other collaborative team members to foster an honest and respectful communication. And very importantly, the team models the kind of behavior that they would hope their clients follow. And modeling behavior is very important. So if an attorney tries to take control of the process, it's not going to model collaboration or cooperation. So a collaborative attorney has to be very mindful of how their body language, how their communication, how their style of moving a discussion forward impacts their clients and models behavior for their clients, and also how it syncs with the rest of the collaborative team. So the concept of being in control doesn't really apply to collaborative divorce because it really is a team effort. Another shift is disclosure and communication. In traditional litigation, it certainly is often the attorney's instinct to limit disclosure as much as possible to only what's necessary or what's requested. That is not the attitude and is not the process in collaborative divorce. In collaborative divorce, the concept is that both attorneys are not adversaries, but they're collaborative partners. and they're referred to as collaborative counsel. And in that collaboration, they share all disclosure and all documents that are relevant openly. And so the focus isn't on limiting disclosure, it's on openly sharing and expanding disclosure as much as is healthy and necessary to foster the most comprehensive and effective negotiations and dialogue. Really understanding the way a problem is defined often dictates the outcome. And through the collaborative process, the questions and the problems are defined in a very different way than they're defined in litigation. Again, the focus is on relationship building, on cooperation, on fostering open and honest communication, and working as a team. Attorneys manage the process, but the clients determine the outcome. Well, since we've discussed that the collaborative effort, the collaborative divorce, really involves an entire team, during this discussion, I'm going to go over all of the team members and their roles. But the first team member that I'd like to talk about, of course, is the attorney. So I would like to now discuss and turn to the role of the collaborative attorney as part of the collaborative team. The first role of the attorney is education. The attorney educates. Before an education process, actually, let me step back. Before an attorney can really serve well in the role of educator, the attorney needs to have some training in identifying the learning styles, different learning styles of different parties. Some clients learn by listening, some clients learn by reading. So having a really fruitful discussion with your client and having a really good understanding of what their learning style is and what is the best way for them to process, accept, and understand information is really important, because that will greatly enhance the education role. Of course, the collaborative process needs to be described in detail to the client, and that's something the attorney would do. And the attorney needs to make sure the client understands what is involved in the scope of the representation, which would be articulated in the retainer agreement. The client needs to know what's involved and what's expected of them in the process, which is all laid out in the participation agreement, which they need to understand completely and be willing to sign. So again, the attorney educates the client about the participation agreement and reviews that very carefully with the client. Of course, the attorney also provides legal advice. If children are involved, the attorney would explain the role of the child specialist and how the child specialist functions, assists, and participates in the collaborative process. The attorney discusses the roles of the other professionals as well, including what a divorce coach would do and what a financial neutral would do, and then would make a recommendation about what professionals would serve well on that team given the specific needs of that client. The attorney does, the next thing that's an important function of the attorney is to do considerable individual work with the client. And that is preparing the client for the process, preparing the client for each team meeting, and really guiding the client in the focus of the process. Assisting a client in a future-focused way, assisting a client in identifying their goals and their needs, and having the client and building faith and confidence in the process does a tremendous amount to reduce the client's anxiety. When a client's anxiety is reduced, their learning ability and their focus increases dramatically. Anxiety is a block to learning and a block to moving forward in a positive way. So a very important role of the attorney is really to facilitate the reduction of anxiety by really guiding the client. Again, identifying and prioritizing the client's needs and helping the client really self-identify with those needs is an important role. assisting the client to look at long and short-term goals, and helping really the client assess and understand which goals are long-term, which goals are short-term, and how to prioritize those goals is an important part of the process. And assisting the client in promoting a communication style that is positive, non-adversarial, and enhance a safe environment in which that can be done. The attorney is also a process facilitator. The attorney co-manages meetings with collaborative counterparts and with other team members, and assists with setting agendas, discussing and identifying goals and needs and interests to move the process forward. I would like to now turn our attention to the retainer agreement and what the retainer agreement would look like in a collaborative divorce case versus a regular litigated case. And I also want to note that when I talk about the retainer agreement and participation agreement, these are not documents that are just developed by each attorney on their own. There's a tremendous amount of resources that are available through the Collaborative Law Institute of Illinois, and if any attorney is interested in pursuing this practice and becomes a fellow of the Collaborative Law Institute, through their training they get model documents for everything that's really involved in a collaborative case. So by prefacing that, I'd like to now talk about the retainer agreement. The key parts that are different in a retainer agreement for collaborative